Well, Dr. Dimitrios Giannoulopoulos is Deputy Head of Brunel Law School and member of the Executive Council of the International Forum for Legal Development. He joins us here in the studio. Thanks very much indeed. Why has he not been read his rights yet, do you think?
Well, the Miranda rights are mainly the right to silence, to be notified of one's right to silence, the right to be represented by a lawyer during custodial interrogation, and the right to speak to a lawyer before you are interrogated by the police. Interestingly, in this case, there is a fine distinction between intelligence and evidence. And the prosecutors want to gather intelligence before they're interested in getting evidence, before they can look at securing a conviction of the suspect. Therefore, they do not want the suspect to be represented by a lawyer at this stage.
Now, based on the circumstances, is he likely to be tried under state law or federal law? What's your take on that?
Well, he will be tried under federal law. However, there have been calls for the military justice system to be used instead. But I do not see that happening. I think the Obama administration has learned from the lessons of the past, and they will be moving in the direction of the normal criminal justice system. Indeed,
but it's very political, this issue, isn't it?
Well, Miranda itself is one of the most controversial decisions of all time. It has been decided in 1966, it has been recently reaffirmed back in 2000, and yet it still causes a lot of confusion and a lot of debate in the States. There is a conflict between due process, constitutional rights on the one hand, and then the protection of the public. And this case is a perfect illustration of why this conflict exists.
Now, what do you think his defense lawyers would be looking for as their client faces the death penalty, possibly?
Well, they would have to create to think very constructively, to use their imagination to come up with a proper defense. Right now, I find it difficult to find a basis for them to defend the capital sentence, to defend against the capital sentence.
If he is proved to be guilty of this particular crime, could the bomb be described as a weapon of mass destruction?
I think it would be quite difficult to do that. Okay. I think under normal criminal justice principles that would not happen.
How thin a line is there between protecting his rights and defending society? In other words, what is the thin line between the two?
Well, it is obviously quite a delicate issue, especially when the interests are so high here. However, the Supreme Court has constructed these rights, and it had such difficult situations in mind. Yes, they put the rights to the test, but it's exactly such cases that call for serious respect and serious application of constitutional rights.
Indeed. Obviously, as you mentioned earlier, intelligence gathering is almost the reason for why he hasn't had his rights read to him. But in later, because if it comes to a criminal trial, it'll be years down the line. Do you think years down the line, the fact that he wasn't read his rights will be brought up as maybe a reason for letting him off?
It will certainly be brought up unless the what is called the public safety exception is used here. And US officials have said that not reading the suspect his rights could be done under this exception. So that exception was again created by the US Supreme Court back in 1984, and it allows the police to interrogate the suspect without reading them their rights for a particular period of time. What will be critical here will be whether there is an immediate danger, immediate threat to the public. If the US officials, if the police can demonstrate that, if the FBI can demonstrate that, then the exception will apply, and any evidence gathered at this stage will be admissible. If not, the evidence might be struck out. But as I said at the beginning of the interview, what seems to be of primary importance here is gathering the intelligence rather than so much convicting the guilty. It's a fine and delicate question.
So what sort of timeline are we looking at? It's going to take a while for prosecutors to marshal their evidence?
Indeed, I mean, under traditional criminal justice principles applying in the States, they would have around 48 hours to interrogate the suspect. That is, if they proceed within the normal criminal justice framework. From then on, it will be a matter of processing the information, and things will go down the normal route of criminal prosecution. However, if the authorities were to take the opposite route of military justice, we could end up in a situation of legal black holes like we saw in Guantanamo. And from an effectiveness point of view, this is not necessarily a good road to take.
Thanks very much indeed. The irony is, of course, he can't speak because he's got a throat problem. Thank you very much indeed.
You're very welcome.
Okay.